Okay, all right. Thank you, everybody, for attending tonight. We appreciate everyone taking the time out of their evening to join us. All right, so what I'm going to do is I'm going to share my screen. Okay, share. Okay, perfect. So, week 2, communication pointers and matters relating to children. So tonight as our guest speaker is Mylene de Guzman. I am Jennifer B. I'm going to be the moderator and chair tonight. Before we begin, I want to do a territorial acknowledgement. So we would like to acknowledge that we are on the traditional, ancestral, and unceded territories of Musqueam, Squamish, and Tsleil-Waututh nations. For any of our new participants, just to do a quick recap of what AC Friends of Court is about. So AC Friends of Court stands for Michi Cure Friends of Court. AC is a nonprofit organization. AC began in 2011 with its first legal forms workshop being held in the offices of the Access Justice Center, which is located in the back of the provincial courthouse at 800 Hornby Street. Our legal forms workshops help British Columbians access affordable legal help for a variety of areas of law. At present, approximately 45% of AC clients are family law clients, such as yourself. The AC Family Law School is the first program of its kind in BC, so we're having a good time learning together. I want to take this time to acknowledge some people who have generously contributed to AC School for Family Law. Without them, this would not be happening. Kylie Wong from Black Robber, Don Batista, our Executive Director for AC, Dana Cornwell, Project Manager for the National Self-Represented Litigants Project, and Andrew Pilliard, Director for the National Self-Represented Litigants Project in the Western region. So just a reminder to all of our students, AC Family Law School does not give legal advice. These sessions provide legal information only. So I just wanted to take this time to kind of go over what legal advice is versus legal information, because I know last class we did have quite a few questions, just about the topics we were talking about, but also some of them were kind of getting into borderline legal advice. We also got some emails about that too, about specifics of certain participants' cases. So legal advice. Legal advice is answering a question or providing information that is specific and directly linked to someone's legal case. So an example question is, my ex says that because I moved out of the house, I'm no longer legally entitled to the rights of the house, nor will I receive financial compensation from the house. Is this true? If I answer that question, I would be giving legal advice. Example 2, I was a stay-at-home parent during my marriage and did not make an income. Am I entitled to spousal support? So again, if I answer that question, that is giving legal advice. So answering either above questions would be providing legal advice because the answer is explaining what that person's legal rights are, and it's very specific to their situation. Legal information, on the other hand, is answering a question or providing information that is more general, not specific, or directly linked to someone's legal case. So for example, I want to start a family court action in Supreme Court. What form do I use and where can I find this form? I can answer that because it's just general information. I'm just telling you what the form is called and where to find it. Example 2, what is the difference between guardianship and parental responsibilities? So I can answer that question because I'm just telling you what each of these words stand, like what they mean and what the difference is. But I cannot tell you if you specifically are a guardian to your child, because again, that would be giving some legal advice. So answering either above question would count as legal information because the information received is general and not directly linked to someone's legal case. So just a reminder for housekeeping, all sessions are being recorded and will be emailed to the registrant. So some of you might have noticed we haven't emailed last week's session yet. We're having some technical difficulties trying to upload last week's video. So most likely some point this week, you'll probably be getting 2 emails of the recording. So tonight's and last week's. So we appreciate your patience. We are trying to work that out, and you will be receiving basically 2 emails with 2 separate recordings and any materials or PowerPoint slides that we have been using. So for anyone who hasn't yet, and I think most of you have, please send your participation agreement if you haven't yet. Please mute your microphones and feel free to turn off your video if you do want to turn off your video because it's being recorded. Any questions you have, please put them in the chat box. Again, we do have a lot of participants tonight, so we do ask that your questions only be directed to what is being presented, not specific to your case, but just if you just need clarification on any of the information you're receiving tonight. Please respect others when communicating, and if you have any questions after tonight, you can email them to info@litigantschoolbc.com. So again, please be respectful of any of the speakers, AC volunteers and staff and other registrants. A reminder that any kind of abusive or harassing language or behavior will not be tolerated. We reserve the right to remove any individual who engages in that behavior that the course facilitators determine to be disruptive, abusive, or harassing. So tonight about our guest speaker is Mylene de Guzman. She is a family law lawyer, mediator, arbitrator, and parenting coordinator. Mylene was called to the bar in 1996 and has been working exclusively in family law since that time. Mylene has been an accredited mediator and arbitrator since 2015 and an accredited parenting coordinator since 2018. Mylene sits on the following boards: the Canadian Bar Association, the BC branch, as the second vice president. Mylene's on the Association of Legal Aid Lawyers, a roster member of the Access Pro Bono, on the board for Rise Women's Legal Center, and was the former president of the New Westminster Bar Association. So this week's objectives is about communicating effectively. So communicating with your ex when there is high conflict or safety concerns, speaking with opposing counsel if there's opposing counsel representing your former spouse, speaking with your children if your children kind of catch wind of what's happening with the family situation. Understand the concepts of best interest of the child in matters such as parenting time, parenting responsibilities, and child support. Understand how your child can access services at the Child and Youth Legal Center, and gain an understanding of the Family Maintenance Enforcement Program, because I understand that there was some questions about the Family Maintenance Enforcement Program last week. So today's outline, and we're going to try to go by this, but sometimes things derail, so it might be, we might jump from topic to topic. But tonight's outline will be about the Family Maintenance Enforcement Program. What is it? How does it work? How to enroll with FMEP and register orders or agreements? How does FMEP collect non-payment for support, and how does arrears work? Communication pointers, so communicating effectively, understanding the concepts of the best interest of the children, and we'll have some time for some Q&A. All right, so I'm going to hand it over to Mylene to start talking about family maintenance enforcement.
Hi, good evening, everyone. Thank you for joining us this evening and participating fully in the information that we're going to share this evening. So Jennifer was kind enough to set out some of the experience that I have, and part of that we listed because it's actually going to dovetail into the conversation that we have with respect to communications and the children aspect of it. So I'm going to deal first with the Family Maintenance Enforcement Program, because I understand there were some questions that arose in the orientation last week. And so for those of you who attended that, This is going to be a dovetail into perhaps some of the issues that were raised, and how to discuss what the program is about, what it can do for you and with you, and also in the context of your case, for example, or in preparing an agreement, how it can assist. So the Family Maintenance Enforcement Program is an important project by the BC government. It's through the Ministry of the Attorney General. And what it is it's free of charge to all residents of British Columbia. And essentially, it assists with the enforcement and maintenance of support. And this doesn't just mean child support, it also means spousal maintenance that you obtain through either an agreement or an order. And so the Family Maintenance Enforcement Program, I have to say, is actually one of those programs which is, it's an important tool in the tool belt to have as a lawyer or any family law practitioner that has the element of support and maintenance in the discussions between spouses who are separating. And so it's an important resource to know about because once you have a piece of paper that actually has the details of how someone is to be paid or how you are to pay someone, what do you do with that? Especially in the event that spouses stop getting along. So this program is available to both payors and recipients. So those people who actually are required under an agreement or an order to pay the support, and also for recipients of the support itself. And it's amazing. You'd think that the only people that registered in this program would be those who, have money due to them. And that's actually not the case all the time, because there are various reasons why those who are paying maintenance also would like to enroll in the program. And the bottom line for it is because there is some consistency in having sort of an overview of what this payment structure looks like. There's a degree of regularity, and it actually causes less friction between the parties, especially at first when, because the separation may have some acrimonious aspects of it, and it eases the tensions between the parties, believe it or not, especially at the beginning. So the Family Maintenance Enforcement Program, it's always important when you're looking to know and learn about your case to know where it derives from. And so what the Family Maintenance Enforcement Program does is that it refers to the Family Maintenance Enforcement Act. That's where they get their authority to go ahead and act. And that's always the legislation that you're going to be referring to when you want to know what this program can and will do for you, especially if you're on the receiving end of their enforcement. One of the things that you want to know about family maintenance is that, excuse me, I have a bit of a cold, so I have to warn you in advance. I'm going to be clearing my throat a lot, and I might take a bit more frequent pauses just to get some water. In any event, the Family Maintenance Enforcement Program is also one of these programs that have to have something done before they can actually get involved. So what it requires is before you even come to them, you have to have an order of the court or an agreement between the parties that has been filed with the court. So they need a piece of paper with a stamp on it that says that the court acknowledges that this agreement or order is enforceable, and that the Family Maintenance Enforcement can then take over from there. So if you don't have that yet, I know that there are clients in the past that have contacted Family Maintenance Enforcement because there is some legwork that you need to do, and they can get you started, but they actually can't do anything proactive and substantive to collect your monies or to take monies from you until you have that filed agreement or order. Okay, so what you do is that how to enroll is you give your order or agreement to the Family Maintenance Enforcement, and then the wording of the order or agreement that you give them is also something that you want to be mindful of. So an overview of how the Family Maintenance Enforcement Program works at an early stage of your parting of the ways with, your partner, is always a good thing to have, in the roster of knowledge that you want to draw from. So the first is how to enroll, and it's up on the screen as to how you go ahead and do that. And you contact them And it'll come later on in the presentation as to how to go ahead and do that. But in terms of how to enroll, the basic wording of the program will be important. And as I said, there's two kinds of maintenance orders that they enforce. So one will be child support, and then the other will be spousal support. So when we're looking at the words or the aspects, the pieces of the order or agreement that you need, you want to sorry, I'm following the slide, and I'm looking to see because I'm reading from a different script. Okay, so these apply to child support, spousal support, and what's called Section 7 expenses. And as many of you know, Section 7 expenses and child support go hand in hand together, because they're two aspects of what is payable for children that actually are mutually exclusive or independent of one another. But what it means is that when you have an order or an agreement, the element is that you've got a clause in there that says one parent is to pay the other parent. You have to have the names and birth dates of your children, each child to whom the support applies, the commencement date as well as the frequency of payment, the exact amount of each payment, and then the frequency of the payment so that it's periodic. And the reason why that is important is because you would be amazed and surprised to know that if one of those elements is missing from it, it actually delays the process considerably. The Section 7 expenses, which are the expenses apart and aside from the basic child support that you get, is also specific in terms of where, what clauses need to be included. Okay, so you have to have both elements of the child support in there, both the basic child support as well as the Section 7s, in order for them to be enforced. You can't assume that one aspect of child support also includes the other. There has to be two separate elements in there. So the one thing that you want to be mindful of for Section 7 expenses, and these are things like special or extraordinary expenses related to your child. So things like extracurricular activities, medical and dental expenses that are not covered through, normal insurance that you would get through work, for example. Things related to childcare. If your child is older, post-secondary education. There's a section in the Family Law Act that actually applies to Section 7 expenses, and it defines all of those things. I think there are 5. But that's what distinguishes Section 7s from the basic child support. Okay. The other thing that you want to know about these Section 7 expenses is that sometimes there is a tendency for people to actually do it by way of a formula. And they say, okay, well, the FMEP, the childcare is payable, but it's different every month. And so therefore, as soon as I give you a receipt, you have 30 days to pay it. And then the amounts will be calculated based on whatever receipts you receive from the daycare. That's not a good thing to present to FMEP. The more certainty that you have in your agreement or order, the easier it is for enforcement purposes, just because anything that is unclear is difficult to enforce. So in terms of the basic wording then, with regard to spousal support, that also needs to have some specificity, including the name and the birth. You don't need the birth date for the person who is receiving it, but you do need to whom the support is payable, a start date. The termination date is not really as important, but you need a commencement date. You need the exact amount. And then there usually is in the agreement or an order, anything related to if the support expires, like upon the happening of a certain event, or upon the elapse of a certain amount of time that goes by. And FMEP will be mindful of those red flags, or they'll be mindful of those particular dates. But otherwise, as soon as the order or the agreement is with them and it's valid and hasn't been varied, for example, or terminated, you're good to go for enforcement purposes. So the next aspect of it is technically, the technical aspect of how you actually apply. So in terms of applying to FMEP, it's as easy as submitting an application online. If you don't love doing that and you would rather download it and send it in physically, that's fine too. And then you can also do it old school and get an application enrollment form, fill it out, and mail it in. So any way that FMEP can have the information from you, they will accept. So as soon as that happens, FMEP will review the application, will then go ahead and assign an enforcement officer to the case to open it. They'll send you your acknowledgement letter and all the bells and whistles in terms of your, like your username, your PIN, all that you need to keep, because if you have a lawyer acting for you, or even if you want to keep track of it yourself, you want to know this. It's like banking information, to be able to access the system on an as-needed basis. They're going to want a copy of the filed order or agreement from you. And this is the part where if you don't have a filed agreement or order, they'll still take your application, but the open case will be pending. And again, the actual enforcement won't happen until after they have a filed order and agreement. And then everybody that is involved in the program, so both the payor and the recipient, is notified of this. And then a client officer or somebody that you can speak to one-on-one that will be working your case will review the case, and then the process begins. They'll start monitoring it for payment and so forth. Okay, it's a lengthy process, and so the sooner that you can do it, the better, because even if you have the groundwork in place, it's always a good start to try to cut down on the time that you've got to wait. In terms of how FMEP, so the FMEP has very long arms. And so being involved with them on a non-voluntary basis is always something that you want to avoid if you are the payor. And I say this because, first of all, they're tenacious in how they utilize all of the tools in their tool belt to be able to collect. Because I mean, you can appreciate that being an arm of the government, they want to really make sure that they're doing their job, because this is, especially as it relates to child support, this is for the support of the children. So the various methods that they use, for example, is that they can garnish wages. So this is the first part here. They can attach a payer's income. They send it to your employer. They give a copy of the filed order, and FMEP and the employer then work in tandem to actually cut you out of this entirely. This is not a choice thing. They will simply garnish your wages, and it's not just employment income. It's pensions, income tax refunds, GST credits, workers' compensation benefits, rental income, bank accounts, and other assets. As long as they can find resources that would be able to be used to pay support, they will come after those resources. So the other thing that they can do is they can get lump sum amounts as security for child support. So even if, for example, like if a payor has a history of either being late notoriously or not paying, what happens there is that there are security for support payments that you can obtain, or that FMEP can obtain, and they can take large chunks of you for future payment of support up to a certain period. They can file liens against land. They can register orders against land, property that you own. And then they can also lien real property. So things like boats, vehicles, manufactured homes, trailers, that kind of thing. If payments or arrears are more than $2,000, it's likely a negative credit rating on your credit bureau report, because that's one of the first things that FMEP will do to impact negatively on your credit. And then if the arrears are $3,000 or more, there are things that are actually a little bit more prohibitive. So things like canceling or refusing to renew driver's licenses, and things all the way up to canceling or refusing to renew passports and vehicle vehicle licenses, marine licenses, federal aviation licenses, etc. And then another thing that FMEP can do is if the payor owns a corporation or is a major stakeholder in that corporation, they'll what's called lift the corporate veil. They'll say that that person and that corporation are one and the same, and make the corporation liable for the support obligation of that person. So in terms of withdrawing from FMEP is actually, you let them know that this is happening, and it's easier for the recipient for obvious reasons than it is for the payor. So if both can withdraw, but if the recipient wishes to do so, they can simply advise FMEP in writing. And if they want to, one of the things that you want to be mindful is that if they then decide that they want to re-enroll later, things like the arrears that accumulate in that window of time or that time period is actually not going to be included in the second tranche of collection. So if you are a recipient and you are thinking of withdrawing, think about how much is left owing and what it took for you to get there, and see whether on balance it weighs against having to renew your efforts, but wiping the slate clean as it relates to FMEP, because you're going to have to enforce on a new order or agreement that is filed with the court. And it's probably only worth it to do that as a payor if for whatever reason you and the recipient have come to an agreement that you don't need FMEP anymore, and that you actually have built some level of trust between the two of you, that you don't want some of the onerous tools that FMEP can use against the estranged spouse to have to do that. And sometimes that happens, but it's usually the recipient that's withdrawing more so than the payor. And the payor cannot withdraw unless the recipient has also done so in writing. The other thing that they can't withdraw from, the payor, is that if there is interest payments, or if there is what's called a default fee that's owing on it, FMEP will collect that to the end of the file. And I mean, I've seen instances where, because of impecunious circumstances and, they want to withdraw and they don't want FMEP to collect the default fees or the interest, people go to court for that. But it's a special order and it's really hard to get, because if you think about it, these default fees will go back into the pool of resources that the government can draw on in order to administer the program itself. So it's important that these things be collected for FMEP to remain healthy and strong for the people that they represent, especially, as I say, when it relates to child support and Section 7 expenses. The other thing that is important to note on the withdrawal portion of it is that FMEP can also withdraw a recipient if the recipient is simply not being cooperative or particularly forthcoming when it comes to the information that FMEP needs to continue to help them. So non-responsiveness is one, but also side deals are things that are frowned upon. So if, for example, a recipient goes to FMEP and says, listen, I need some muscle in terms of collecting, but really you've taken like a cash payment, for example, one time from that person because that's just what was available that month or whatever, and FMEP doesn't know about it, can't keep track of it. It's a he said, she said situation, or a he said, she said, she said situation that becomes really problematic. So they don't like that. And the other thing that they don't like is that if people who are already registered in the program does their own enforcement actions, because FMEP already has these bundle of tools that we've just discussed. And if, for example, the recipient also then, for example, on their own or goes to a lawyer and says, look, I want to do this, that, and the other thing, that is apart and aside from what FMEP either knows about or is doing for them, that's a problem. So the bottom line for it is that as soon as you enroll with FMEP, it's called a subrogation, which means that you hand over your right to collect or to enforce on your support order, either child support, spousal support, or Section 7 expenses, so that you let FMEP do it for you. And until you are no longer enrolled with them, you allow them the latitude of being able to do that. So in terms of the the overview of FMEP and exactly what it is that it entails, the process itself is lengthy, because once you're enrolled, the idea is for it to be pretty user friendly. So whether you're the payer or the recipient, once you have your PIN number and your your access to the program, you have access online to your own information, including statements and deposits and all of those things. And then you also have access to your caseworker, who also can answer some questions that may arise from time to time, because nothing is ever static when it comes to these things. And sometimes there are changes that occur. One of the things, it's not going to be on the slide, but one of the things that you also want to know is that for both child and spousal support, there can be such things as variation orders. So in terms of variation, if, for example, the amounts change, they either go up or they go down, FMEP can enforce on that. But that's the only way that they can keep track of what's happening on your case. If you call them or your enforcement officer and say, hey, listen, my ex-spouse is making way more money than he or she used to, and therefore you need to increase the amount, and this is what I looked at in the guidelines, and this is how much you should enforce, that is not FMEP's role. So it's the role of either the payer or recipient or their lawyer, legal representative, to actually get a new order or a new agreement in place, excuse me, to enforce. So the key word is that FMEP is there to enforce an order or a filed agreement, and not to get a new one for you. Okay, so excuse me, we're at the end of the overview with regard to the family maintenance enforcement. And I'm looking at the time and I see that although it's easy to suggest that we divide our time equally between the two topics because the next piece that we're going to be speaking about is actually the topic for this evening, which is the communication pointers and matters relating to children. So, excuse me, I'm going to shift it over to Jennifer and see where we're at. I'm looking at the chat. I'm trying not to actually read some of these questions directly as I speak, just so as not to lose my place. But there are some questions I think that people will have that fall under what it is that I can, excuse me, can answer. Some of these questions are in the nature of legal advice, which I think that we're trying to veer away from. So, excuse me, we probably are going to need to jump over some of those questions. Otherwise, Jennifer, how would you like to go about leading us into the next topic, and how you want to answer that or do the questions related to this?
So maybe what we can do now, because we do have time, we can jump into some of the questions that people have about FMEP. So just give me a second here. I was writing out some of the questions as they were coming through, so just bear with me here.
Yes.
Okay, let me just hold up. Okay, so okay, so let me see if I can, I'm just gonna read this out loud and just see if I can rephrase it in such a way. So wondering if FMEP is used for children of the marriage. So I'm guessing it's about, like, can FMEP still be involved if the children are over 19 and have a disability, or over 19 and are in post-secondary school?
So the answer to that question is yes, but we always have to look to the root of what FMEP is enforcing. And so that will be found in your order or agreement, and that will be found in the definition section of exactly what child of the relationship or child of the marriage means. So the question, there's two parts of the answer. The first is, yes, child support and maintenance Section 7 expenses do apply to children who are over 19, and by reason of, and one of the criteria is by reason of disability or some other criteria, unable to withdraw from parental control. That's sort of the key to that definition. So will FMEP enforce for children over 19? Yes, they will. As long as the order has that, I mean, it doesn't even have to be that specific. If there's no termination date for the child support, they're going to enforce exactly what's in that order or the agreement. So that's the first part of the answer. The second part of the answer is you don't actually, FMEP cannot define that. So for example, if the child is 19 years old, you usually get like a letter from FMEP, you meaning the recipient, because the payer will say, oh, you know what, 19 is what am I saying? 19 is the maximum age of a child in the province. There's a more elegant phrase of that. It just escapes me at the moment. But in any event, the date of the age of majority. And so if the child is already at the date of majority or older, usually the payer will say, you know, knock, knock, you got to terminate my payments, or they'll simply stop paying. It's not FMEP's job to actually mitigate between what the payor and the recipient might argue about in terms of children over 19. It has to be sourced within your order or agreement.
Another question here. So can one register the order made in BC against someone who lives in Alberta? So I feel like part of that, it's borderline.
Yeah, let me dance the line to a more general response to that. Okay, anybody who resides in British Columbia can actually avail themselves of FMEP services. I know that in one of the slides that I included in the presentation, there are things like what's called ISO, or interjurisdictional support orders. And then this gets into the whole conversation about, you know, FMEP for BC orders versus you know, are they able to enforce orders that are outside of the jurisdiction of British Columbia? And the answer to that is yes. And the qualified answer to that is they are able to do that if those orders or agreements are from jurisdictions that have what's called reciprocal recognition. And so that gets, I mean, that's a little bit more technical than probably we want to deal with this evening. So the answer is they can enforce orders or agreements outside of BC.
Okay, so the next question is, can FMEP only garnish support orders, or can they also deal with outstanding equalization and settlement payments? I think that one is.
Yeah, so that's a tricky one because so it's family maintenance. It's in the definition of the maintenance orders, right? So the idea there is that how to answer this. Okay, so in an order, you, and it's not even sometimes this black and white, but you'll have a portion of it that is to do with support and maintenance, and then you'll have a portion of it that's to do with compensation payment or an equalization payment and so forth, right? FMEP is allowed to obtain payments from, you know, things that are owned or able to be accessed by a payor with regards to the source of the maintenance. But they're not going to delve into the enforcement of or collection of things that are not related to maintenance. So again, you got to look to the wording of your order or agreement. And if it's to do with, you know, like a compensation payment or an equalization payment, you get into a tricky ground. Likely not is the answer.
This one, I don't know if we can answer this one. I think it's more it's more of like, I think for someone who works for FMEP, but can FMEP staff help collect information for child support purposes if the other party has properties outside of Canada?
So, I mean, far be it for me to know with any degree of intricacy what the resources for FMEP are in terms of collecting the information. Suffice it to say that they have like long-reaching, as I said, arms and resources to be able to collect information, including things like credit ratings and where the person is located. And so, can the staff? So I don't want to misunderstand the question. So is it that can the staff collect that information in order to assist FMEP to do their job for collection purposes? Yeah, they've got quite a bit of resources, quite a few resources that they are able to avail themselves of in order to find the payor, but more importantly, where it is, the sources of where it is that they can enforce the maintenance.
Okay, so I have a long question here, so I'm just gonna quickly read it. Okay, so it's a two-part question. So the first one is, if the recipient moved outside of BC after the FMEP enrollment, does this change the status of the enrollment? So if they move out to a different country, I guess what happens with that enrollment itself or the file?
Okay, so the first part of that question is to do with ISO, so interjurisdictional support orders, and whether or not the recipient has moved outside of BC to a jurisdiction that will actually recognize the order that is made in BC. That's actually true for anything, including parenting stuff, right? So the answer is, does that change the status of the enrollment? It might. Because will BC then be able to continue to, let's say the payor resides in BC, will they be able to collect for enforcement purposes? Yes, but then you have to register that order in the jurisdiction to where the recipient has moved to, and then it's, you know, recognized in BC. So there are a couple of hoops that you have to jump through. So I see that that's the first part of that question. And then also, if the recipient receives child support payments, but then reports that it is not paid, is there a penalty to the recipient? Yeah, they can get kicked out of the program, is kind of the bottom line to that, is that there are also instances that I've seen where, you know, the recipient has been overpaid and they don't report the overpayment, or, you know, there's some misbehaviors that occur by the recipient that actually jeopardizes either their continued enrollment in the FMEP, or even so far as to have to pay back some of that support that they've received, or maintenance that they've received. And there's various ways to payback is not the right phrase, but equalize it back to what was owed. And again, that's probably beyond the purview of what we're talking about this evening, but the answer is a qualified yes.
Okay, okay, so if an agreement has an order that is maintained until the children are children of the marriage, what does that mean? I'm assuming are not children of the marriage.
Sorry, if an agreement has an order that is maintained until the children are children of the marriage, what does that mean? Oh, okay. So I think that the question is what defines children of the marriage? And so when you look to the legislation, if you're looking at children of the marriage, there's a different definition for it under the Divorce Act and also in the Family Law Act. But basically, in the Family Law Act, until they reach the age of majority, which is 19 years of age, or are unable by reason of, and then it's the whole, the checklist that we talked about, to withdraw from parental control. So if it says that it's maintained until children are children of the marriage, FMEP may get a nudge from usually the payor when one of the kids hits 19, or when they start hitting 19. And then there might be enough gray area that they say, look, you know what, we need more guidance or information, and this order or agreement needs to be clarified.
Okay, and then we have another one here. I don't know. I feel like part of this might be really borderline legal advice. It's about paying child support in Section 7 expenses. So if they're paying the full amount for child support without any parenting time, do they still need to pay Section 7 expenses?
I was muted. So again, let me take it outside of the purview of like specificity and actual legal advice. And let's just say this, that child support and maintenance is independent of parenting rights, responsibilities, and parenting time and arrangements. They're two mutually independent and exclusive topics. So when you try to conflate the two, and when you say, okay, because I don't get this, or I'm not able to do this, I then therefore quid pro quo need to have like some break when it comes to maintenance, it's a false equivalency. You can't do that. So your maintenance and support obligation is independent of what you can or cannot do as it relates to your children.
Okay, so actually, I think that's it for questions for, oh. Okay, does it have to explicitly say in the agreement payment for a child after 19? I think you did touch on that a little earlier. So regarding the order and agreement, does it have to explicitly say that it stops at 19 or?
So the relevant piece of this is actually it kind of it relates back to one of the previous questions, which is that if the order defines it as children of the marriage for long as so and so and so and so are children of the marriage under, and then it will cite the legislation, either Divorce Act or the Family Law Act. It should include wording in the order or agreement for enforcement purposes that gives guidance to the enforcement officer. I mean, that's what we would say if we're giving some specificity to any order or agreement that we're drafting. And so does it have to explicitly say? No, it doesn't. It can say simply children of marriage or children of the relationship. The problem with it is that you're going to put FMEP in the untenable position of having to try to define what that phrase means if the parties don't agree, and they're just going to send you back to either your lawyer or to, you know, however way you can redefine or vary the order agreement that you already have.
Okay. And then there was one more other question. It was about, I guess, what happens with child support and somebody passes away? Does it move to the estate?
So that also is a tricky one, and it actually connects the dots with regards to what the agreement or the order says in relation to security for maintenance. So in an agreement, it's usually easier to see because you have things like what happens in the event that a party passes away, right? And then it references the Estate Act, the Estate Administration Act, those kinds of things. And so for both child and spousal support, it may be, well, especially for child support, if the payer has passed away, yes, the estate can be liable and likely will be liable to continue to pay that maintenance. And that actually holds true for spousal support as well.
Okay. All right. Well, I think that's it for questions about FMEP. So it's 6:21 right now. We can either do an early break or we can jump into the next segment. I don't know how anyone feels about having a quick 10-15 minute stretch. We can do 15-minute stretch if anybody wants to start right now. Say yes or no. I'll give everyone a minute to answer in the chat. Okay, yes, I'm hearing yes, break. Okay, so it's 6:22, so 15 minutes. I think that's good. All right, so that means, okay, if I have good math, that means 6:37.
Yep.
All right, so we'll see everybody back at 6:37.
Sounds good.
Okay, all right, welcome back, everybody. I did see on the break, we did have one more question about FMEP. Does FMEP collect a percentage of payments enforced?
So I think that question is related to how does FMEP get funded or paid, or, are they entitled to any portion that is allotted to the recipient? And the answer is no, that's not how that's funded. So it's, this program is through the government Ministry of the Attorney General's office. And when I was talking about default fees earlier, and things related to, you know, uh, things other than what you would be ordered to pay, such as interest. I'm not suggesting that FMEP takes the interest either, because that's actually a part of what should be, enforced as part of the order. I expect that things like default fees and other methods of funding FMEP happens apart from the actual collection. The collection, the amount that they receive from the payor related to the maintenance and interest payments themselves goes to the recipient and the kids.
Okay. All right, so I'm going to share my screen. Okay. And me and Mylene did talk about this earlier. So some of the slides are going to be probably a little bit not syncing up with what's being discussed, but I'm just going to do my best to go through. But Mylene, just talk away.
Okay. So this is actually the point of this program and what I was asked to speak about initially. And when we approach this topic, it's so huge. It's so voluminous, and there's so many pieces to unpack that it was hard to, figure out how I was going to prepare for this. And so what I decided that I was going to do was actually give a brief overview of what it is that I usually tell clients at sort of the initial consultation stage, or what it is that they need to know from me, in my view, as part of their, things to be able to draw from, to be able to have as many options available to them to think about next steps. So the way that this was posed to me was that by the end of the session, you need to know how to do three things. The first is how to communicate effectively on your file. So whether this is with an ex where there's high conflict and safety, or whether it's with opposing counsel and it's counsel to counsel, or you're a self-represented litigant and you're dealing with a lawyer on the other side, and also with your kids. So that's the first thing, communication. The second is, what is the meaning of and what is the context of best interests of the child? And the reason why this is important is that this is the seminal concept upon which all decisions related to children are made by the court, and also where parties are guided when they are coming up with an agreement that is going to bind them to the extent of their parenting for their children. Okay. The third thing that you need to know as part of exploring your options moving forward is also how, what resources are available to your child, independent of your lawyer, for example, if you've got one, or independent of you. And it's important, especially when the children are older, to give them some sense of independence and also autonomy when it comes to this situation, because you can appreciate that while it's happening to the parents themselves, the children, who are the subject matter usually of many of the things that you're going to be in conflict about, are at the core of this thing. And so at the very front end of what we should recognize is that when you are dealing with matters relating to children, different than 40 years ago, 50 years ago, even when I first started practicing this, like almost 30 years ago, the focus was different. And the focus, even though best interests of the child has always been a phrase that, there is a focus on the children, it wasn't quite that way in a practical sense. It was, what did one parent have to say vis-a-vis what the other parent? So it was a he said, she said situation in that instance, or she said, he said, he said, he said. So the focus has now become quite distinctly different, and it's reflected in the way that the Family Law Act is now worded. and the reference points that we make to that. Okay, so I don't want to get into the weeds too much in terms of the definitions of what is in the legislation, but one of the two things that you want to know is whenever you're trying to convince either the court or the other side to your point of view, apart from the fact pattern that you relate, you also have to have reference to what is actually enforceable. So that is the legislation or the law, like what pieces of the legislation can you persuade them with, and also what the case law of similar situations that are like yours have done in the past that the courts have been convinced by, and what were the decisions rendered. So if you have an appreciation that those are your two core source materials, you're always going to have good information to form the basis of how you move forward. Okay, so when we're looking at the definition of best interest of the child, we're going to actually focus on the definition that is given by the Family Law Act, which is the primary piece of legislation that you're going to be looking at when you're dealing with children in British Columbia, because that is the law that governs. And so when you look at best interest of the child, it's actually similar in many ways to the definition in the Divorce Act. So I invite you, if you want to compare the two, to go ahead and make that reference. But it's actually the part in the Family Law Act that starts with what's called care and time with the children. And it's not a coincidence that the law starts with what is the premise for who it is that we're doing this for in the first place. So best interest of the child is under section 37 of the legislation. And so Jennifer, it's going to be, in one of this is there it is. And so it's actually going to be further down under care and time with the children. And it's to do with numbers A through, I just want to make sure that I'm reading this. Okay. So A through, I think it's G, in terms of things like the child's emotional well-being, the child's views, the nature and strength of the children's relationship with not just the parents, but other people in the child's life, the history of the child's care, child's need for stability, and then stability given, where they are in their age group and what stage of development. And then it shifts to the ability of the parents or the guardians that are actually going to be putting these mechanisms into place. So the ability of each parent to exercise their responsibilities. And here's one of the key components: the impact of family violence on a child's safety, security, and well-being. When that violence is directed either towards a child or another family member. And then whether the actions of the person responsible for family violence impairs that ability to care for the children. And then other arrangements that would require the child's guardians to cooperate with one another related to the children. So we've got that up on the screen, and it's certainly a checklist that is helpful to refer to when you need to laser focus on what is exactly the point of what it is that you're trying to achieve. Okay, so if we go from a child-centric view of what best interest of the child means, then we can look at, the different components of what goes into an order or an agreement related to kids. Okay, so before, we used to use words like, guardianship hasn't changed, but, we'll talk about sort of what that means, what bundle of rights and responsibilities that relates to. But it used to be called custody. It's now parenting arrangements and parenting responsibilities. Used to be called access. It's now called parenting time. And the terminology has evolved along with the definition of best interest of the children. So when you're looking at communicating effectively, for example, with people related to your case, let's look at the first obvious one. When there is a significant high conflict or safety concern with the other spouse. So keeping in mind what the best interest of the child definition means, and also keeping in mind, what the components are in relation to things like family violence and how that impacts the situation. One of the things that you want to know is that the Family Law Act also starts from the premise that staying out of court is a good thing. That in fact, as part of their mandate or part of the way that they've outlined, how they do things, there is a section in here that is related to the role of different dispute resolution professionals that actually have their core authority outlined in the Family Law Act to give them some weight as to how they act in these situations. Okay, so when we look at communicating effectively with your ex when there are high conflict issues or where there are safety concerns, it might not always be appropriate to have ongoing direct communications with your ex-spouse in that event. And hopefully you are in a situation of some safety and some, a place where you can find some equilibrium to be able to discuss things with an equality of bargaining power, so that there is no power imbalance that is in place that may or may not have existed during the relationship or marriage that is actually the impediment to you being able to speak to one another and come to an agreement when it comes to, what to do with the children. And when we're looking at high conflict situations or safety concerns, the power imbalance is very evident. And that's where it dovetails into discussions about family violence. And one of the things that, not just lawyers, but dispute resolution professionals have to really be mindful of, and actually is part of our mandate to have to check for. So when Jennifer was going through, the laundry list, I've been around a long time, and so therefore, I've had the opportunity to be able to, get trained in various areas. So even though I do a lot of litigation, and that's actually not to my credit, it's something that I've also wanted to add to with regard to other training, such as mediation, arbitration, parenting coordination, and what's called the collaborative method of practicing family law. So if, for example, you are in a situation, the situation respecting, how to move forward from here and what it is that you need to assess as part of your options. If you are a self-represented person, one of the things that you need to take a look at is when to ask for assistance. And I know lawyers are expensive, dispute resolution people, the whole process is prohibitively expensive in many regards. But there are various resources, AC being, foremost among them, where you can actually get some information and resources so that this power imbalance, is addressed in a meaningful way, and so that you can move forward with some assurance that you are speaking in a venue that actually hears your concerns. Okay, so when there are high conflict or safety concerns, and when it is not appropriate or effective, frankly, for you to be speaking with your spouse directly, this is when it becomes important to engage the process in a way that actually allows you to speak freely. So if you're going to hire a lawyer, that's one way to do it, because you are then insulated from having to have those direct communications, which would have been problematic in the relationship. Or other dispute resolution professionals, such as a mediator. A family justice counselor also becomes really, really important in this discussion, because like family maintenance enforcement, the family justice counselor's role and their participation in things related to child-centric matters cannot be overstated. So this is a program, a group of people who are able to be accessed without the usual charges that are necessary to, retain or engage a lawyer and other professionals, perhaps, and that they can help you with written agreements, and also some advice with regard to not advice, some direction with regards to, how to move your case moving forward. And they provide, mediation services in the way of trying to get parties together to a consensus point of view, to speak about child-related matters, things like parenting responsibilities, parenting time, guardianship, and support. The one thing that family justice counselors don't do is they don't deal with things related to property. So division of property and debt is not something that they will deal with. And so usually family justice counselors are involved in instances where there is a provincial court file. Like if you're talking about like a court process, it's usually in the provincial, because it actually it is similar to the jurisdiction that the provincial court has. They don't do things related to property. So the other thing that you want to be able to do is to communicate with opposing counsel. And so communicating with opposing counsel is difficult if you are a self-represented litigant and you don't know exactly, how to navigate through things that are a matter of course for us. And I have to say that for the most part, when we are engaging with self-represented litigants, we actually have a higher duty of care to be really mindful of the fact that this is not, language or a familiarity that our other colleagues who also do this every day will have. And so it's something that hopefully your experience will be that when you are communicating with opposing counsel on the other side, and you explain to them that, this is where you're at and you're doing your best to cooperate with what it is that they're expecting you to provide. And, if you're candid with them about that, you'll establish a mutually workable engagement and communication so that, they're not throwing rules at you. We're not throwing, okay, well, according to this or that of the Family Law Act, and I can do this and that and the other thing too. It's really not the point. And I think that the key to communicating with opposing counsel, if you yourself don't have counsel, is that you want to be very candid about what efforts, as long as you're making efforts, you're making. And short of actually getting legal advice from that opposing counsel, because sometimes you're like, okay, well, what do I do about this, that, or the other thing? And it borders on that. I'm hoping that your experience is that opposing counsel will be more helpful than a hindrance to you. And then with your children, with regards to how to communicate with your children, I think that that's one of the things also that we're going to be speaking about later as to what resources they can access and who it is that they can speak to. But you yourself, one of the things that you want to focus on is this, that your children's experience in processing the separation between you and your partner is an entirely different one than you're experiencing yourself. And by and large, the perspective that they have is very conflicted in the sense that they have presumably loyalty and love to both parties who are in conflict. So they're challenged in a way different than the way that you are challenged in, negotiating this situation. And it's really important to also acknowledge that they may need help that you at that point cannot provide, and another voice or another resource that can help direct their feelings, their thoughts in a way that you are unable to at that point, because you happen to be one of the two feuding sides to whom they owe loyalty and love, or experience or express loyalty and love. So it's a good idea to know what resources are out there with regards to children. And it really just is, it depends on the age of the children what kind of resources are available to them. And one of the things that you want to know is that speaking to somebody is an important, well, it's a personal decision if you're an adult, but if you are a child, it's an important option to give to your child. So that might look like being able to ask the counselors at school to intervene to the extent that, your kids can go to them as a resource because they're experiencing some troubles at school, or not even that, just to, as kind of a touch point. Another way to do it is that many of us have coverage through our respective employment, or there are ad hoc services that are available so that our kids are able to speak to somebody. And whether it's, for 1 or 2 or 10 times, or whether it's for a more ongoing basis, there is a difference between speaking to a counselor or a therapist for the purposes of litigation, or for the purposes of fleshing out kind of the conflict between you and your spouse, or for therapeutic purposes to simply help your child to work through this, probably the most difficult time in their life that they will ever experience, along with you, and to actually give them the room and the latitude, and frankly the recognition that this is something that they might want or need, that you can't provide to them. So check your a lot of us don't know what is covered in our respective insurance and all of those things. And I would invite you to do that as one of the first things that you do, is to see what kind of help is available for children, as well as you, to be able to avail yourself of that. Okay. The other aspect of utilizing, with some degree of success, the dispute resolution process is to actually educate, or to inform yourself of the different options other than a lawyer, to be able to speak with. And the good news again is that I can't think of a colleague, with any exception, that won't give initial consultations or advice, usually free of charge, for the first part of an hour. And that's actually helpful to have. And so Amici Curie is another program that does that. And there are various programs throughout the province that'll allow you to be able to put the bits and pieces together of how best to, not just the procedural aspects of that, but also how to communicate, how to engage, how to articulate yourself in a way, through either court or through the negotiation process, that puts your strongest and your best foot forward. Okay, so when you look at the different resources or the people that are available to assist with that, so mediation is one where I think is probably the most common option that people know about. And what that is that sometimes there are family law lawyers that we go through a mediation process, and we get accredited in the same way as, for example, psychologists may also be mediators, family justice counselors. It's the same aspect of the training that we employ in helping people that are in conflict. So the mediation process also has its own rules and regulations, and mediation, arbitration, family parenting coordination, these things have its root in the Family Law Act, where it gets its definition from, and where it gets its authority from. So when you're looking at mediation, you can do it at any point in the process, and you can actually do it as well mid-stride. So even if, for example, you're already in a situation where litigation has started, in fact, there are tools that force the mediation to happen. And that might be strongly worded, but to compel the other side to participate in this, that's how strongly the courts and the legislation feels about alternative ways to accomplish a settlement, short of the court process. There are other options in terms of arbitration, for example. Arbitration is different than mediation in this main sense. If you have agreed to arbitrate, at the end of the day, your arbitrator, especially when it's called a mediation arbitration, will try to get you to a point of consensus. But if you cannot come to a consensus, the arbitrator will act as a judge and will make a binding determination that you are then obligated to see through. So that is the difference between a mediation and an arbitration. And arbitration has that element in it of enforceability with respect to in respect of their decision making. Parenting coordination also is something that you can avail yourself of. And parenting coordination usually happens when there is already an order or an agreement in place that's not working quite the way that is optimal for the family. And when you're looking at parenting coordination, you almost have your own judge, basically, for your family, or resource for your family that will listen, will compel cooperation to try to come to a consensus. And short of that, if they're not able to do that, then to also have decision-making powers that are bindable or binding, rather, right? That give some degree of certainty to the parties within the context of their parenting coordination situation itself. The parenting coordination is usually timed. So it could be anywhere from an engagement of 1 year to 2 years, or, however way that goes. But that is parenting coordination. So in terms of the way that you can communicate, the other avenues to avail yourself with, the people that can help other than lawyers, and also the way that you can engage the process in something different than simply filing things and going to court and duking it out there is becoming the rule rather than the exception, whereas before it used to be the other way around. The other thing that we want to discuss is with regards to how concepts of best interest of the child relates to things like parenting time, parenting responsibilities, and even child support. So when you look at best interest of the child, which is a global definition, and it's like in a nutshell, the primary focus being whatever it is that will help your child to continue to thrive and be best supported, not just emotionally and psychologically, but financially as well. One of the things that you want to take a look at are to have things like a very strong basis for either an agreement or an order to be as comprehensive as possible, to avoid having to rethink things at a later date, or to have a diffuseness that can actually be affected later on as your lives evolve. And with the introduction, for example, of things that your children will be involved with, they get older, they partner with dates and extracurricular activities and all of those kinds of things, and you yourself or your ex-spouse themselves also don't live in a vacuum. And with the dynamic of your family shifting and changing and growing to include other people, the dialogue between the parties and the two parents also becomes very changeable, and it'll vary through the years. So you want to try to at the very early stages get each other used to a different way of communicating than perhaps what caused problems in your relationship previously, but more importantly, some tools that would be available for you to be able to draw from, like mediation process, parenting coordination, those kinds of things, to assist you from time to time, if that becomes relevant. So in terms then of how you can best support your children through this, the Child and Youth Legal Center is an excellent resource for kids who are older, who are actually able to articulate their feelings on a subject, and for them to feel that they are being heard. And so in terms of what it is that this program does, they can call in. It's anonymous. It's a situation where they will be given an ear by professionals that are well familiar with these kinds of situations, and give your child the direction that he or she may need, or they may need, in order to make their own decisions. Because as the child gets older, their place in your family law dynamic and your family law case also shifts. So it's a resource among many that is available to your children. And one of the things, for example, okay, so the Child and Youth Legal Center is an intake resource that it can be as general as, okay, well, I'm not really sure what I need exactly, and so therefore, how is it that you can help? And it's really as an outreach. You call the number and you get, a situation where they do the intake. The age of the children that are assisted by this program is up to 19 years of age, and that goes with the age of majority in the province. And so they will help children anywhere from 19 and under. And again, it'll depend on the age of your child as to how they are able to, express themselves and to ask for the help that this resource provides. So again, it's anonymous for your kids. They really need that assurance of not just anonymity, but complete safety, where they can be as candid as they want to be, in the same way that they would be as therapists. So in the same way as they would with a therapist, is what I meant to say. So, and again, it's entirely confidential, and it's entirely voluntary for the children to be able to know that this is something that is their resource, and something that is not either required or requested of them by either parent, and that the person on the other side that is listening to them is there for them, and them alone. So I'm mindful of time, and I know that without getting into direct responses for some people who may want some answers, what I will always do is whatever question Jennifer chooses to pose to me, if I think it's bordering on legal advice, I'll just make it more general.
Sounds good. So one question we had, I'm just going to pull it up quickly because my notes aren't So it was about, so I'm not quite sure if this was just the way it was typed out. It was what to do if OC does want to communicate. So I'm not sure if it does want to communicate or does not want to communicate. I know what I've had from some clients who are self-represented at work. Sometimes they're like, am I allowed to talk to opposing counsel? I don't know. So sometimes they'll ignore them. So I guess I can flip it into two questions. Can you talk to the opposing counsel if you don't have a lawyer? Oh, you're on mute.
Yes,
I do that too.
of course I am. I do it all the time. So the answer is yes, you can. And in fact, here's the general rule: is that if you have a lawyer, they must talk to the opposing counsel. Opposing counsel cannot. So we as lawyers cannot talk to a represented litigant without going through their lawyer. Okay, so if you are self-represented and you've expressed that to the other lawyer, you're the only one that can communicate with that other lawyer.
And then I guess the flip side of that one is, what can you do if the opposing counsel does not communicate with you?
So that's troubling in and of itself. And so what you want to do first and foremost is to continue to try to engage them in communication, and written is better. So for example, if you try calling them and they don't respond to your calls, and you determine who their paralegal or their legal assistant is, and you are also being ignored there, which is, I would have to say, unusual, but if that's the case, you want to have their commitment that at some point they will answer you, because it may be that they're on holidays, or, you know, like there's a time constraint or whatever. But a consistent ignoring of somebody who, you know, is the self-represented litigant on the other side of a file is a cause for a huge concern and should not be happening. And so if it does happen, you want to make sure that you paper it, basically that you actually communicate in writing, and that recourse then will probably make itself evident if and when you commence an action in court, and you know, that behavior continues. I expect that it'll be resolved at the front end of a file, but that would be troubling to hear if that continued.
And another one, so I did have some people bring up a few times about power imbalance.
Yeah.
I was trying to see if I can get more targeted questions about that, because I do understand, you know, when it comes to certain dynamics of you know, of a former relationship and a former couple, one might have a, I don't want to say the upper leg, but you know, there might be more, they might have more in their arsenal than the other party. So I guess, like, if it comes to that case, like for a power imbalance, like, oh, hopefully I got a targeted used against me, I guess. For a power imbalance, so I'm just trying to think of like some types of like scenarios where a power imbalance would be, and the only thing I can think of is like one party having all the funds and a lawyer and can drag a litigation out. That might be a general example. Or I guess maybe using words against another party, if maybe there was an agreement in, and I think this might be borderlining legal advice, but I guess a discussion outside of the lawyers or the court, and then it's then used against them. My apologies, everyone. I'm trying to think of some scenarios where a power imbalance would happen, and how to best address it.
Yep. So let's do it this way. So power imbalance is actually one of the phrases that I should have avoided like the plague, in terms of just like, you know, kind of like throwing it out there and letting it sit without context or definition in a more fulsome way. It's the same thing as when you throw out, you know, the phrase best interest of the child, and these kinds of things without like a deeper context. And so let me just say this, in terms of power imbalance, it can take many forms. And when we talk about it, and when it is alleged, you have to unpack it to what that actually means in specific terms to that family. So Jennifer, as you say, it may take the form of a financial power imbalance, where the way that the relationship unfolded is that, you know, one spouse definitely holds the purse strings because they're the ones that worked outside of the home, or they just happen to be better at math and you know, was doing all of the banking and keeping track of, you know, like financial housekeeping matters, all that. Anywhere from that range to a power imbalance that actually is reflective of family violence, whether it's psychological, physical, you know, and emotional. And so power imbalance runs the gamut of that. And it actually exists whenever you feel that in communicating with the other side, your point of view or your wishes are just not facilitated or not given any weight. And it could be a feeling that you have, but it could, you know, manifest itself and actually result in specific incidences or things throughout the context of your relationship that involves anywhere from you know, getting into arguments, police involvement, that kind of thing, or even simply just shutting down because somebody communicates differently with you or at you in a way where there isn't a reciprocity in that communication. So when we're talking about the way that parties communicate, that's why it's important when you part ways to try to address that power balance in a way that is immediate. So As you say, Jennifer, there are people who can afford lawyers. Many of us can't. And so that in and of itself feels like a power imbalance right there, where, you can't ask for the same assistance from somebody who knows the rules because they deal with the rules every day, and you're scrambling to try to put that together for yourself. So thankfully, there are resources, and the court is very mindful of this, and there are other inbuilt mechanisms, hopefully also through lawyers, that will recognize that it's important to have two sides engage in it. Because here's the bottom line is that if a power balance exists and you just don't wanna, and you have separated and parted ways, I mean, there are other repercussions, and we won't get into that as to what you just don't agree, or you don't come to a resolution, and that's in nobody's interest. So in general, what I will say is that when we're dealing with these kinds of power imbalances, I guess the point that I was trying to make is that there are other resources short of the stick that used to be, utilized way more often than we do these days, about simply going to court and making the other side do whatever it is that would be compliant with, what that litigating party wants them to do.
So this one was an example was if their former spouse tells their lawyer not to, collaborate. So I guess, not try to, negotiate, not try to, basically they just want to go to court. They want to go to court and they don't even want to attempt to negotiate with the one party. What's something that they could do to try to steer it out of court, I guess.
So here's the thing, excuse me, that I think relates to one of the other questions that I thought I saw on the chat earlier as well, which is, how do you force somebody into mediation? How do you compel them to, that course of action? And when I said that there are tools that are available to you through the legislation, there is what's called a notice to mediate, which can be issued at any point in the at any point in the court process once you have initiated an action. So it presupposes that, that has been done. And I think that in instances where, you're trying to, let's just leave it at this. The notice to mediate is mandated and can be issued to a party that will compel them to go to the mediation, or to get what's called, I think it's, it's a default. Where if you don't participate in it's a certificate of non-attendance, or something that says you had a notice to mediate issued against you, you didn't participate in getting that squared away, and therefore there needs to be an adverse inference drawn on the fact that you didn't participate, and judges take judicial notice of that refusal to participate, because dispute resolution and taking the steps necessary to explore that avenue is something that is not only suggested strongly, it's in the legislation.
Actually, I have a question. Just going back to using a judicial case manager. And you might have already touched on it. I might have missed it, but if you have a Supreme Court file, can you utilize them, or is it for provincial court cases only?
Sorry, so the Family Justice Counselor, you mean?
Yeah, that's what I meant.
Okay.
Sorry.
So the Family Justice Counselor's office is usually administered through, like they've got their own office and their own auspices, and I believe that you can utilize them in any event, but they're usually closely aligned with matters that are already in provincial court. And so the usual kind of manifestation of them is that if, people are engaged in a provincial court process, and then they are sent to the Family Justice Counselor's office to discuss and flesh out things that will lead to a written agreement, that's usually the context that we see them in. I believe that you can still avail yourself of them, but so can you for duty counsel too, for example, right? And other mechanisms, not just for dispute resolution, but also for litigation.
Perfect. So we got two questions here. So one is, does the court give more weight to physical violence rather than emotional, mental?
No. violence is violence. And that is why the legislation is actually drafted in a much more nuanced way than, for example, because in drafting this legislation, there were a lot of people that, you know, became resources for how family violence actually manifests itself in a family dynamic. And family violence is not simply physical in nature. It's not simply one that is witnessed or experienced by, you know, the recipient of that violence. It's actually in seeing family violence being perpetuated against another family member. So the definition is expansive and not one trumps the other. Family violence is family violence.
Would a form of family violence show in like financial?
Yes. Yes, and it's interesting because I want to be careful because then it gets into the weeds in terms of, you know, like some case law and some arguments that have been made with regards to that. But, you know, as part and parcel of somebody's emotional health and well-being, and as part and parcel of like this equality of bargaining power that we've touched on and sort of somewhat unpacked a little bit tonight, it all goes into that, right? So the way that you construct your narrative, if necessary, to the court, but to whoever it is that has got a way to determine your case, has to include all of the things that you experience. And you'll appreciate that sometimes we can't identify what's happening to us because we just don't know that it's bad or wrong. And so that's actually part of the work that needs to happen is to be able to speak with somebody who says to you, hey, and by the way, that wasn't supposed to happen. And that's called this. And that's part of the work, that the really hard work that needs to happen.
Thank you for that. Sorry, I didn't mean to throw you a curveball there.
Yeah, no, it's an important question.
So this question here is, after filing a notice of family claim, can they then do a notice to mediate, or?
Yep.
Yeah.
Yep. You can.
All right. And then what would be an example of emotional violence?
Yeah. So it runs the gamut, emotional and psychological violence, you know, so undermining the other partner, things like undermining somebody's parenting by speaking ill of the other parent to the children. Things like, you know, actual insults that are levied. I mean, the more obvious ones are ones that are easily identifiable. They're the more kind of subversive ones, and that are like, you're like, that just doesn't feel right. And so therefore, is that bad? It's kind of those things that are harder to unpack and to recognize.
And for this one, I don't know if it's going to border on legal advice. Can financial violence be connected to best interests of the child? The other parent's ability to provide for that child?
Yeah, so the way that that works is this, and they're actually clear in the legislation about this, is that when you look at the best interest of the child test or the criteria involved with it, if family violence, you have to examine it, first of all, to define it properly, right? That includes both emotional, psychological, and physical family violence, among others. And if it compromises that parent's ability to parent a child, not because, you know, like they perpetuated the family violence against that child, but it has to, you got to look at each criteria in reference to that actual incident or example of family violence. So the convoluted answer to that question is that it's really, yes, it can be connected and is often connected to the best interest of the child. And it is also connected to the parent's ability to provide for the child in examples of financial inequality.
All right, well, thank you. So we're almost at 7:30. That was amazing. We had such good engagement tonight. Thank you, everybody. If someone has one last oh, I'm done talking. If anyone has one last minute question they want to squeeze in, otherwise, I think everyone's free to go tonight. Again, everyone, thank you so much. It was wonderful engagement by everybody. Some really good discussions, some really great questions. And Mylene, like, I learned a lot. That was absolutely amazing. And thank you so much for taking the time and, you know, time tonight to share your insights and your knowledge. And I can't thank you enough.
No, you know what, I have to say that everybody on this call and who continue to go to these clinics are really, really brave. And not only are you really, really brave, but your proactiveness and, kind of talking to people like Jennifer and getting help is going to inure to your benefit. So I really appreciated the time to speak to everybody tonight. And I really wish everybody the best of luck. And you have to stay safe.
Okay, so I think that's it for tonight. So next week is week 3, property division and spousal support. So thank you again, everybody, for taking the time to come
Thank you
tonight.
so much.
And thank you again, Mylene. I
Yes,
really, really
my
appreciate it.
pleasure.
And all the engagement from everyone tonight. It was some really good questions and some really good conversation.
Yes.
So I'm gonna stop the recording now.